Are we finally about to see it? Elaine's reign of misrepresentation coming to an end? Has she finally gone too far? We're going to talk about the insurance litigation and everything that it exposes about the lies Amber Heard has been telling. And it now sure looks like those lies have been substantiated and repeated by her attorney, Elaine Bredehoft. We're going to take a look. So on Friday night, most of the world was occupied with the Deadline story about that trash memorandum that Amber Heard has filed over her failure to verify the information about juror number 15 before she agreed he was unbiased and set him on the jury. With the suggestion that, the verdict is now thrown into chaos and the trial is uncertain. Of course, we know that that's nonsense. Might talk about it a little more in another video. But at this same time, who is doing real journalism once again? Shockingly, TMZ is out on the forefront reporting that there is new litigation against Amber Heard by an insurance company. New York Marine, the provider of a $1 million general liability policy, is suing Amber Heard and arguing that they have no liability to pay for any part of the defamation judgment because it was the product of willful misconduct by Amber Heard. And they are arguing that they have no further duty to defend her, meaning they don't want to be paying any costs for any appeal. They're done, and they're asking for a judge to give them the approval of that course of action. Well, this story got picked up and covered by some other outlets as well, and in some of those stories, we found a little bit of a hidden reference here to separate litigation that was filed back in 2001 between New York Marine and another insurance company, Travelers, and that they were arguing about who needed to pay for what. Now, there has long been at least speculation that Travelers had some role in Amber Heard's defense, whether paying for it, whether hiring an attorney, because one of their senior vice presidents of something or other, Pamela Johnson, had been seen in attendance in several days with Amber Heard's team at the Depp versus Heard trial. But this is really the first confirmation that we've gotten about that lawsuit. So I have found this 2001 lawsuit and I have looked at some of those documents. There's a reason why we haven't heard of it before now, and it's because the parties chose to use some discretion to not mention Amber Heard. However, it is crystal clear from the allegations in the complaint that this is the case that they are referring to, that this is essentially a situation where both New York Marine and Travelers Insurance have provided policies to Amber Heard that include some type of coverage for defamation. And so as a result, both of them have a duty to defend. And what they're essentially arguing about in this lawsuit is what exactly does that duty to defend mean? Now, according to New York Marine, their story of what transpired is that they received Amber Heard's tender, her request that they provide her with a defense in the defamation case in September of 2020. And at that point, they went and essentially approved of the lawyer that she had already hired, who was the very first person to appear for her in the case, an attorney from a local Fairfax firm called Cameron McAvoy. So New York Marine basically said, great, we'll go ahead and just pay for this guy. So Travelers took a different perspective. Their view was that they would have to provide a separate independent counsel of Amber Heard's own choosing. And according to this lawsuit, the very first attorney that they funded was Roberta Kaplan. And then upon Roberta Kaplan withdrawing from representation, they assumed to provide Elaine Bredehoft to Amber Heard as her lawyer. This lawsuit has a lot of really juicy details about the milking of the fees that happened in this case. What we see is that one of the primary disputes between New York Marine and Travelers Insurance is that Travelers first basically didn't impose any kind of limits on what Elaine could charge for her rate. They simply put a cap of $2.5 million on the total defense. Well, Elaine ran through that in, was it even a year? I mean, it was well before trial. So then New York Marine went and basically required her to adjust her rates. They waived the cap, but essentially required that she charge a slightly lower hourly rate to be more reflective of rates in the community. And after making that revision, Travelers has then incurred over $5 million in legal costs. Now, this is as of about April of 2022. So this is right at the very beginning stages of the trial. We haven't even paid for the trial yet when we're talking about these kinds of numbers. So it's pretty eye-watering stuff, isn't it? Well, this is all just sort of a point of interest, I suppose, were it not for the fact that the payment of these attorney fees was a really important part of Amber Heard's explanation for why she wasn't able to make those charitable donations to the ACLU and the Children's Hospital of Los Angeles.
You didn't donate it. It's a yes or no.
I haven't been able to to fulfill those.
So that's a no,
obligations.
right, Ms. Heard?
I made the pledge. I want to be very clear. I pledged the entirety. I haven't been able to fulfill those pledges because I've been sued.
And have you completely fulfilled your donations to the ACLU and the Children's Hospital?
I have not yet.
And why not?
Because Johnny sued me for $50 million in March of 2019. And I have spent over $6 million.
Objection, Your Honor. This is a motion in limine.
And in fact, Elaine Bredehoft herself, in her closing arguments, represented to the jury that Amber Heard had paid $6 million in legal fees.
At the end of the day, she's made $1 million in payments to them, but then she got sued here and hasn't been able to because she spent $6 million in attorney's fees. That is unrefuted. She still intends to pay those pledges, honor those pledges.
Now, this looks like a problem because this looks pretty verifiably not true. And not only not true, Elaine Bredehoft knew it was not true because she knew it was Travelers paying her bills, not Amber Heard. And yet she deliberately represented to the jury that Amber Heard had paid these amounts. And you can see this kind of look of horror that passes over Camille's face when she hears this statement being made. Don't know how much Camille and Team Depp knew about this other lawsuit. Maybe they knew about it, maybe they didn't. We knew from the previous objection that Amber Heard's payment of legal fees had been the subject of a prior motion in limine, so maybe that's what Camille was upset about. But it's entirely possible that she knows perfectly well about this underlying litigation and as a result knew as soon as Elaine said that it was not true. So we've been making a point here of looking at the ethical rules that apply to lawyers and their conduct. And we've talked about misstatements of fact before. So we're going to take a look at that again, because as you probably remember, the rules are real permissive when it comes to what you don't say. You're pretty much never going to run into difficulty if you keep your mouth shut, because you have duties of confidentiality, duties of loyalty, generally no duty to disclose information. That's the role of the other party, to elicit the facts that are damaging to your position. But if you decide to open your mouth, you better be scrupulously honest about it, because if you're not, that's a violation. And guys, based on this, I really think that what we saw in that closing argument, yeah, that's bar complaint worthy. That is a flat out misrepresentation of fact. Does not reflect well on Elaine Bredehoft, on Judge Azcarati's courtroom, on the Virginia bar, for this type of thing to be accepted and to go unpunished. So there it is, guys. Pretty much in black and white, as far as I'm concerned, words coming out of Elaine's mouth in her closing argument, representations of fact that cannot be substantiated. She knows that they were not true. She knew they weren't true when Amber said them. And rather than correcting them, she doubled down, she repeated them. This is dishonest conduct. I hope the Virginia Bar Association takes notice.